All right, well, good morning and welcome to another Radcliffe Chambers Junior Programme webinar. I'm Matt Mills, and alongside me in the commentary box, apparently wearing the same suit, is Nick Macklam. Please note this session will be recorded, so you'll be able to watch it again afterwards if once just isn't enough. And we'll also be sending you our slides afterwards, so you'll be able to access all the hyperlinks that we've put in them. So, the coronavirus pandemic is affecting us in countless fundamental ways. But today we're going to be talking to you about what really matters. Litigation procedure. It's going to be wild. But why are we bothering to do this? Well, in short, because there's just so much new material out there. For example, as of Monday, we've already had 132 pieces of legislation with the word coronavirus in the title, 176 cases concerning coronavirus, and over 100 pieces of advice or guidance from the courts and tribunals. Now, many of these sources are very specific to certain courts or to certain types of claim, so they wouldn't really form the basis of a useful talk. Instead, what we're going to try and do is make some general marks about the 6 main stages in the litigation process. Firstly, we'll talk about issuing a claim. Secondly, we'll talk about undertaking disclosure, case management and interim applications, preparing witness evidence, trials, and post-trial matters. And we'll split this between us 50-50, so you don't have to listen to my boring voice the entire morning. Let's start at the beginning then, issuing a claim. What's the very first thing you need to be able to issue a claim? Well, a court to issue it for you. But as we know, some of the courts, and in fact quite a lot of them, have been closed over the last few weeks. So how do you know which ones are open or not? Fortunately, in this context, the Ministry of Justice has provided a surprisingly useful website called the Courts and Tribunals Tracker. It shows you courts that are open only for staff, or entirely suspended. According to the latest spreadsheet, all the senior courts, that is the High Court and above, are all still open for business, but 16 of the 150 county courts are closed. These 16, yes, I am naming and shaming. Fortunately though, for 12 of those courts, the Ministry of Justice provided a phone number to a nearby different court which has been assigned to take over the work. There's only these four courts, which seem to have fallen down a black hole of being suspended without any other provision. Now, in my view, 4 out of 150 courts isn't too bad, but having said that, I bet you we all now get a flurry of claims to issue in the Slough County Court. So you've issued your claim. What's next? Well, obviously you need to serve it. Bumper sticker is optional, but strongly recommended. The law of service has not actually formally changed since COVID started, but there are other practical difficulties. Since March, it's been much more difficult for each of us to get to a postbox safely. And since April, the foreign process section of the Queen's Bench Division has been entirely suspended. So the multi-million-dollar question in most cases is likely to be, can you serve something by email rather than by post? So, can you? Well, as you all know, the starting point is Rule 6.3 of the CPR, which says that you can serve things electronically in accordance with Practice Direction 6A. Now, as you know, Practice Direction 6A, in a nutshell, requires you to get written confirmation from the other side in advance that they'll accept email service. But don't forget the really helpful rule that if they've stated an email address on their particulars of claim or defence, that's good enough. Now, some parties are probably going to be willing to accept service by email. If they can't get to their office, if they can't get to their normal address, there's no real point in forcing you to send the documents somewhere they'll never get them. So people may be reasonable here. And in fact, for this reason, some government departments have simply adopted a blanket policy of accepting electronic service. For example, the Treasury Solicitor, the Welsh Government, and the Scottish Attorney General have all said they'll accept service electronically at the moment. But let's say you don't get consent and you do just serve something by email, for example, because you can't get to a postbox. Will the court retrospectively allow you to do this? Well, as you always know, the answer to any good legal question is, it depends. The court does have power to authorise alternative service or recognise something you've already done under Rule 6.15 of the CPR. In addition, Rule 3.10 allows the court to correct any error of procedure. In general, when looking at Rule 6.15, the court will look for a good reason to justify serving something outside of the normal rules. And in particular, the court will look at two things. Firstly, whether it will come to the defendant's attention if it's served in the way you suggest, and whether the government took reasonable steps to try and serve it normally. Now that's quite general, but there are two more specific High Court decisions we can rely on here. The first is the Interim petroleum case. There, Mr. Justice Popwell said that Rule 3.10 can be used to save a claimant who served particulars of claim electronically without permission. Excuse me. He initially doubted whether this could be used to save a claim form that was served electronically. He thought the two were different. He said a claim form is the more fundamental step that establishes jurisdiction over the defendant, and that couldn't be saved by Rule 3.10. But fortunately, in the Bank of Baroda case, Sarah Cockerell QC disagreed. She said Rule 3.10 can be used to save you if you've served a claim form electronically without written permission, at least where you've tried to do something else and there's no limitation defence. But all of these cases come with the obvious warning. I'm sure you're all very familiar of the Barton and Wright-Hassel decision. In just 8 short paragraphs, Lord Sumption came down pretty hard on a litigant who tried to serve something by email without permission at the last second. Now, in my view, the facts were fairly extreme. The claimant was an experienced litigator. He knew he was courting danger, and Wright-Hassel would have been deprived of a limitation defence if the court allowed retrospective alternative service. Furthermore, in my view, if you have legitimate and clearly explained reasons relating to COVID why you can't serve something normally, in my view, a court should take that into account and give that great weight. These are exceptional times. But as always, the best thing you can do is talk openly and early with the other side. Explain your reasons for wanting to serve something electronically and ask for their consent. And if the consent's not forthcoming, try and get an application in before the deadline for service, and ideally before any limitation period expires. And that's the way you'll have the best chance of having service approved alternatively. The other tricky issue right now is personal service. We are quite literally prohibited from coming within 2 meters of each other. So, can personal service still work? To answer this question, I'm going to tell you a brief story of Russian oligarchs. Your job is to vote on whether you think the claimant did or did not validly serve the defendant. And hopefully shortly, a little pop-up will appear on your screen asking you to vote. Foss Agro is apparently one of the world's largest suppliers of phosphate-based fertilizer, which is surprisingly hard to say. The company's based in Russia, and Mr. Andrew Guriev was the deputy chairman. His family owned 45% of the company, and he was worth a cool £4 billion. On the other hand, Mr. Alexander Gorbachev was a senior executive in the company. Mr. Gorbachev claimed that the deputy chairman had made 5 oral declarations of trust over shares worth £1 billion in his favour. Apparently these oral declarations were made in a sauna and a London pub. I don't know about you, but I frequently make £1 billion declarations of trust down the pub on a boozy Friday night. To serve Mr. Guriev, Mr. Gorbachev hired a process server. And of course, the process server tracked him down to the Mayfair Hotel in London, where I imagine he was enjoying a nice afternoon tea. When Mr. Guriev left the Mayfair, the process server tried to give him the papers, but his 4 bodyguards got in the way. The process server literally couldn't get to Mr. Guriev. So what the process server did is he left the papers on the floor next to Mr. Guriev's Rolls Royce. And here is a picture from the actual process server's mobile phone. Here is Mr. Guriev. He got into the right-hand side of his Rolls Royce. Now, he said this for 2 reasons. Firstly, Mr. Guriev knew that this was a legal claim that was being served on him. And secondly, the documents were left sufficiently near to him and in his eye line. But crucially, in my view, paragraph 64, which is on the screen, is very important here. What the judge said is that the process server got as near to Mr. Guriev as he could have done, risking his own safety. Now, in my view, a lenient judge could adopt that language in the COVID world and say that a process server cannot safely get within 2 meters of someone. And so that's the closest they can get. and provided they identify the document and leave it in the eye line of the defendant 2 meters in front of them, in my view, there's a good argument that personal service does still work today. Nick.
Right, I'm going to consider 3 topics: disclosure, interim applications and case management matters, and witness statements. And as regards disclosure, I'm going to look at this from 2 perspectives. The first relates to practical problems in relation to disclosure orders, which have already been made in current litigation, and how to deal with such problems. And secondly, I'm going to think about potential pitfalls in relation to disclosure in the months and years to come. So as regards practical problems and how to deal with them, well, let's assume a piece of litigation is ongoing, an order for disclosure has already been made, the deadline's coming up, but you're going to have trouble dealing with it because of the COVID-19 pandemic. And it's easy to think of scenarios for why that might be the case. Say a client wants to bring a batch of hard copy documents to you for review. That's not possible for whatever reason. You don't want to have the client send the documents to you at home if your offices are closed. Or, for instance, the client might have to self-isolate because of symptoms and they can't get the documents to you. So the deadline's coming up, and what should you do? Well, firstly, try to stop the problem from arising in the first place. So be proactive. Litigators need to be organised at the best of times, and the current pandemic makes that even more important. So review your ongoing cases. What deadlines are coming up? Not only in the next few weeks, but in the next few months. Start putting plans together with your clients now. Who's going to do what? When? Think about moving your usual deadlines forward. If you would normally allow 2 or 3 weeks to do something, allow 4 or 5. Working remotely almost always makes things more complicated and adds more time. The second tip is to be creative. Think around the problem. Is there a way around it? If your client is going to send you the documents for review, but can't do so, can the client carry out the review themselves with your instructions? Can the documents be scanned in and sent to you? The temptation might be to make an application to court for an extension, but the court, if an application is made, will want to be satisfied that reasonable steps have been taken to try and work around the problem. It's been a prevailing view that COVID-19 results in a softer approach by courts to matters of case management, and to some extent that is true, but courts, particularly the High Court, are trying to keep things as business as usual as much as possible. Thirdly, be sensible. If it really is unavoidable that an extension of time is going to be needed, identify that as soon as possible and contact the other side. Rule 3.8 of the CPR is set out on the slide, and it provides that in the circumstances listed in paragraph 3, unless the court orders otherwise, the time for doing particular acts may be extended by the prior written agreement of the parties for up to a maximum of 28 days, provided that the extension doesn't put at risk any hearing date. Now, as a result of the COVID-19 pandemic, Practice Direction 51ZA has been brought in, and this provides, among other things, that during the period of time that the direction is in force, which is the 30th of October this year, the reference in Rule 3.8 to 28 days has been extended to 56 days. So it's possible to agree extensions of up to 56 days with the other party without the permission of the court. And if longer is needed, the court will consider it on the papers in the first instance. But what if the other side aren't playing ball? Well, in that scenario, we can go back to our old friend Denton. Denton emphasises the need for parties to litigation to cooperate. And I've included on the slides 3 particular passages from Denton, which are particularly relevant in this context. So the court said that the parties should be ready to agree limited but reasonable extensions of time of up to 28 days, and that's now 56 days. It should be very much the exceptional case where a contested application for relief from sanctions is necessary. And the court should be more ready in the future to penalise opportunism, with heavy cost sanctions being imposed where parties have behaved unreasonably in refusing to agree extensions of time. And so if the other side are not minded to agree to your extension and you think they're acting unreasonably in this regard, then you should refer them to the relevant paragraphs of Denton and invite them to reconsider their position. Now, as regards potential pitfalls in the months and years to come, well, there are two aspects to this that I'd like to consider. The first is that if you have a CMC coming up, we'll make sure that you build in sufficient time to accommodate disclosure taking place in the current climate. Think critically about how much time is going to be needed. Contact the client to discuss whether your thinking about how long will be needed is realistic. What sort of searches will need to be undertaken? Are the documents in question accessible? If not now, when will they be? Are you going to be seeking an unusual direction in relation to disclosure? And if so, think about what exactly you'll be seeking and why well in advance. Another angle to this is what disclosure might look like in the coming years, because before the pandemic, there are often fairly standard places to carry out searches for disclosure purposes. So the hard copy files, electronic files stored locally on computers, and other document repositories like cloud software, external servers, and emails, and etc. How might the pandemic affect this? Well, one way it might affect the position is that because of the pandemic, many businesses are communicating differently, at least internally. So a quick chat by telephone might now be replaced with a message on Microsoft Teams. What might formerly have been a minuted in-person meeting might have been replaced by a Zoom call. An email might be replaced by an instant message on Skype for Business. And this may cause issues for disclosure later on down the line, because it's really crucial to consider to what extent these more informal communications are being stored. Is there a record of the Zoom call? Are the Microsoft Teams chat logs being recorded? Because if these things are being stored, standard disclosure obligations will most likely extend to them. And so that means that our business clients really need now to make informed choices about what tools their businesses should be using for internal communications, because there will be legitimate business reasons for wanting certain types of information to be saved and archived, and other types of communications not to be. And businesses need to have a detailed understanding in respect of each platform that they're using of what data is stored by each platform in question, where it is saved, for how long, how it can be accessed and searched. And this, of course, matters not just in terms of complying with disclosure obligations down the line, but because in any piece of litigation, it's vital to have all the documentary evidence available to the lawyers as early as possible, so that a realistic assessment of the merits of the case can be carried out. And no one wants to be in a position some years down the line where a few weeks before trial, someone realizes, oh, there was this important conversation internally that took place on Zoom, and actually that's disclosable, and it's very damaging to the case. So in this environment, in my view, lawyers should be reaching out to their clients proactively by way of business development, and this provides a useful way of doing so. Now, as regards to case management and interim applications, I'm going to deal first with interim applications, and in doing so, I'll address separately the position in the county courts and in the High Court, because in my experience, they really are worlds apart. So as regards county courts, well, county courts are underfunded, their staff are overworked, and that means that in the usual course of events, the administration at county courts can be mixed. And the pandemic really has compounded these problems because there are significantly fewer staff, and that is really having an impact. Also, the county courts don't have available to them the technology that one sees in the High Court. And so they were significantly less well equipped to deal with the almost overnight shift from in-person hearings to remote hearings. And I'm sure all concerned in the county courts are doing the very best they can in these very difficult circumstances. And I don't mean to criticise them in what I'm about to say, but I think it's important when advising clients that we're realistic about what the practical position is on the ground in county courts. And so I'm going to set out what, in my experience, can be expected if you want to make an interim application or deal with the county courts on an interim matter. So firstly, limited or no communication. I've been involved in cases where emails sent to the court inquiries inbox have gone unanswered. Telephone calls either go unanswered or you're left on hold for sometimes a number of hours before you're able to speak to someone. Another thing that I've seen is last-minute adjournments. So the court decides late in the day that it simply doesn't have the capacity to hear all of the list of cases and adjourns some to make notice. Relatedly, I've seen soft adjournments, so adjournments granted on the application of a party for which there was no real basis, that the courts simply do not wish to run the risk of spending time on a case which may need to be adjourned or which cannot effectively be heard, and so it will just be adjourned out of the list rather than potentially waste court time which could be spent dealing with other cases. Another dynamic that I've seen is interim hearings being adjourned and then relisted many, many months into the future. So by way of example, I was recently involved in a case in a county court, which was an insolvency matter, and it concerned an application to set aside a statutory demand. Now, that's not a very urgent application, but it is the sort of application that ought to be heard reasonably swiftly, because either someone's being threatened with insolvency when they shouldn't be, or because someone is insolvent and a creditor's been prevented from presenting a bankruptcy petition. In my case, the application to set aside the statutory demand was made in October of last year. It was listed for March of this year, and so already a significant period of months. And then shortly before it was due to be heard, the court adjourned it of its own motion, and it was then relisted for November of this year, i.e. more than a year after the application had been made. I've also heard anecdotally of the technology simply not working effectively. So there being real issues with parties not being dialed in for telephone hearings, or the judge not being able to hear parties where a video hearing has been attempted, and so on. And because of the issues with administration, I've seen cases where applications and documents have been sent to court and they simply haven't been actioned because there isn't the staff available to deal with it, or for whatever reason. And the consequence of that is that if the court doesn't action it or give it a reference number, you can't then effectively chase it up. It becomes a lottery of when and whether you'll hear about it again. So as regards the High Court, and particularly in the Rolls building, my experience is very different. There's good communication from the court to the parties. There's a reluctance to adjourn unless the hearing can't take place in the interest of justice. And that might be where one of the parties is a litigant in person, and for whatever reason, that litigant isn't able to effectively participate in a video hearing, and the matter is not appropriate to be dealt with by telephone. The High Court appears to have good capacity to list matters appropriately, and in my experience, the technology is working very well. I've done a number of hearings in the High Court by video, and the technology has always worked perfectly in my experience. So that is, in a nutshell, what can be expected on the ground as matters stand in my experience. In the High Court, things not wholly different from usual. In the County Court, things are more problematic. So in terms of practical tips in those circumstances, well, I've got a number. First is if you're in a county court and you're considering making an interim application, really assess critically whether it's needed or whether the point could be resolved by consent, and whether it's possible for you to persuade the other side that they should be cooperating. Secondly, in considering the likely outcome of the application in order to advise your client, do factor in the practical realities of the situation. So is the application likely to achieve what you want if it's not going to be dealt with for a number of months, if not longer? If not, are there other ways of achieving your goal? And in this regard, do check whether your application will be considered as priority work which must be done. And there's a link on the slide to a document that sets out what will be considered as priority work which must be done. The list is set out here. Thirdly, this is a situation in which more than ever, the venue for your proceedings can make a real difference. For instance, if you're going to be issuing proceedings which may or may not, which may or will involve an application for interim relief, for instance, an injunction, you will have a much more straightforward time getting that application listed and heard in the High Court if you can justify going there, even if ultimately you get transferred to a county court. Fourthly, think creatively. So I was involved in a case a few weeks ago in which there was a need to make an urgent application to the county court. The court was incredibly difficult to contact for the reasons I've outlined. We weren't able to get an indication from the court of how long it would take to list an urgent application, whether the application would in fact have been treated with urgency. And the problem was compounded by the fact that our application wasn't something listed on the list of priority work which must be done, notwithstanding that it was in fact urgent. And so in the very unusual facts of that case, we managed to get everything transferred and immediately dealt with in the interim applications list in the High Court. Now obviously that won't be a solution in most cases, may not even be an option in most cases, but the point I'm making is that do try to think creatively around the problem to see if you can identify a solution. As regards matters of case management, there are a few things I want to focus on, principally in relation to directions. So firstly, make sure that you factor in sufficient time to do everything. That means thinking through in advance how all of the relevant steps are going to be carried out and what you might have to deal with in the current circumstances, and make sure that the directions are fit for purpose in terms of how things are to be done. Particular things to think about are how are disclosure obligations going to be performed, how a witness statement is going to be taken, more on that shortly. What difficulties, if any, are any experts going to have? For instance, recently, no value was for visiting properties. The position has now changed in relation to that, but do think these things through. How will the experts meeting take place? Is the nature of the dispute such that it's going to be possible for the experts meeting to take place remotely with no problems? Or will there be issues with site visits and things like that? Is a mediation going to take place? If so, how and when? And make sure you build in enough time for it. It's also sensible in heavier cases to build in the possibility, at least, of having a PTR so that a review of the case can be undertaken before trial. And as regards costs, well, at least for the time being, while we're getting used to this new way of working, conducting certain aspects of litigation remotely can take longer for the lawyers to work on it, and therefore it can be correspondingly more expensive. That's particularly so in relation to hearings, because in my experience, the bundles take longer to prepare, the advocacy takes longer to prepare, and the hearings themselves take longer. Now, in my experience, judges recognise, at least while everyone is getting used to this new way of working, that means that costs can be higher than an equivalent in-person hearing. And this should be, in my view, factored into, say, cost budgeting. For instance, by seeking to revise the budget if significant developments occur, For instance, what was previously thought to be an in-person hearing is now going to have to take place remotely, or something of that nature. As regards witness statements, there are a number of things I want to cover. First, how will they be prepared? Second, how will they be signed? And third, some recent changes. Now, as regards the question of how they'll be prepared, well, this matters because it's really important to plan ahead. In the ordinary world, preparing a witness statement will involve taking a proof, sitting down with the client, having all the disclosure available, working through it with the client, and then setting out in writing what the client says in response to the documents and in order to advance their case. And there's a question about how exactly that will be replicated now. For instance, is the same sort of meeting going to be undertaken by Zoom or Teams or Skype, i.e. a video call? If so, how are the documents going to be made available? Is it going to really work? Does the client have the facilities available to them to enable that to happen? Are you going to have to try and do everything by telephone? Are you going to try and do things by email? Or are you going to have to, because of the nature of the dispute or the nature of the client, have an in-person meeting? And if so, how are you going to facilitate that in line with government guidance? This all matters because, as I've said previously, things take a lot longer than you expect when you're having to do everything remotely. And it also matters because now you have to tell the court. So Practice Direction 32, paragraph 18, was recently amended so as to provide, at paragraph 18.1, there was the familiar list here setting out what a witness statement must state, for instance, occupation, whether they're a party to the proceedings, and so on and so forth. And a new requirement has been imposed here. The witness statement also must state the process by which it has been prepared, for example, face-to-face, over the telephone, and or through an interpreter. Now, this isn't a COVID-19 specific provision, but it is one that's been overlooked. And I haven't seen many witness statements produced since April 2020, which has actually complied with this. And so it's important to bear it in mind. As regards how the witness statement is going to be signed, there's a question about whether a witness statement can be signed by way of electronic signature. And the key provisions of the CPR are set out on the slide. So Rule 5.3 provides that where any of the rules or practice direction requires a document to be signed, that requirement shall be satisfied if the signature is printed by computer or other mechanical means. And there's a bit of a debate as to whether that means that witness statements can be signed by way of an electronic signature. And there's one school of thought that says yes, 5.3 clearly applies to a witness statement, and another school of thought saying actually, if you look at Rule 32.4, which sets out that a witness statement has to be signed by a person, there's specific wording there that suggests that actually electronic signatures don't apply to witness statements. And those who are of that school of thought also point to paragraph 4 of Practice Direction 51.0, which refers to documents that are filed by electronic working. Where documents are filed by electronic working, the original signed documents must be retained, and how does that fit in if you're signing a witness statement electronically? There's no authoritative decision to confirm that the effect of Rule 5.3 is that a witness statement can be signed electronically, but I understand there to be a decision of the county courts to that effect, which is often referred to by practitioners in this area. It's a decision of the Liverpool County Court, so it's not binding, but the effect of the decision is that a witness statement can be signed electronically. My own view is that it's probably okay, but why run the risk? I've literally never been involved in a case in which it was not possible to have a wet signature, but the maker of the statement was in a position to apply an electronic signature to the document. So why do it unless absolutely necessary? Finally, this is just by way of reminder rather than anything COVID-19 specific. Don't forget the recent change to Practice Direction 32, which amends the statement of truth in the form set out on the slide. For the most part, I've seen almost all of the witness statements sent to me since this came into force complying with this, but there have been some that have missed it. It's very important to make sure that you don't miss it. So I'll now hand back to Matt.
Thank you very much, Nick. Nick, can you see my slides? Great. Well, the guidance just keeps on coming. I'm going to talk to you about two things in this part: building bundles and tackling trials, all remotely. Now, I imagine that between all 100 of you who are watching this video, you've spent a fair amount of time converting this sort of pile of paper into a beautiful, glossy, hard copy bundle. On behalf of the bar, thank you very much. We couldn't do our job without you. Unfortunately, you've now got to very quickly learn how to do the same thing remotely, probably with no hard copy in front of you, and probably without your phone's fancy photocopier to hand. On top of that, in the last 2 weeks, we've been given guidance, both in specific cases and from the General Ministry of Justice, to explain what those electronic bundles should look like. So I'm going to summarise to you the key points. On the 11th of May, His Honour Judge Hodge QC decided to give a reserve judgment explaining how, in his view, you should prepare an electronic bundle. Now, he expressly said at the start of the judgment he was not criticising the lawyers in that case, and then he went on to criticise the lawyers in that case. Charming. He basically said two things, though. Firstly, only include essential documents. He said those are documents which are indispensable or important in the highest degree. And he said to help work out what you really need, barristers and solicitors should work together, coming up with bundle indexes and bundles. Secondly, he said, make sure the pagination runs sequentially throughout. So don't, for example, have pages 1 to 5 of the claim form, 1 to 5 of the particulars, 1 to 2 of an order. Just have it 1 to 12 throughout. We then turned to the more general Ministry of Justice guidance. And this started way back on the 20th of March, which in coronavirus terms is an age. Officially, the starting point is that you should prepare bundles in PDF or other format. However, please note that some courts expressly only take PDFs. I found guidance from the Court of Protection to this effect, and there might be other courts saying the same thing. Once you've created the bundle, you then got to get it to the court, and this can be done either via C-file, if it's available, or by email, USB, or data room. But the real guidance came out last Monday. This was Mr. Justice Mann giving us key points. Now, at this point, I should say that basically all judges are assuming that at least one lawyer in the process has access to Adobe Pro. I've never used it and I hadn't ever got it until the lockdown, but I decided to get it a couple of weeks ago. And I can honestly say, because I'm stuck inside all of the time, it's changed my life. It's so easy to use, so quick, saves so much time, but other brands are available. Mr. Justice Mann gave essentially 11 tips, which very coincidentally matched the Commercial Bar Association's tips, which had been produced 8 days beforehand. I'll let you draw your own conclusions. The first point is that everybody agrees PDFs should be searchable. Simply having reams of images isn't helpful. Now with Adobe Pro, this is straightforward. You click on the OCR button and it does it for you. Secondly, all documents should appear in portrait mode, even landscape documents, which should apparently appear sideways. Now, personally, I don't think that's very helpful at all, but I am much less important than Mr. Justice Mann, so please do listen to him. Thirdly, the default view for a document should be 100%. That means when you open it, it roughly looks the right size, rather than zooming right in or being absolutely tiny. Again, this is easy to change in Adobe Pro. The fourth point is a bit of a balancing act. On the one hand, judges emphasize the need to keep bundles as short as possible. On the other hand, they want you to put in as much of the relevant material as you can. In reality, in my view, we'll probably end up with a situation similar to before, where you have a core factual bundle and a core authorities bundle, but please do be flexible here and think laterally. I had a case last week, for example, where we had the core documents in one folder, apart from an exhibit which was 250 pages long, and we used that as a separate document because we weren't intending to refer to it much, but it obviously needed to be before the court. Fifthly, this is an unusual and novel idea. The guidance suggests putting a letter in front of your page numbers. So instead of saying 1, 2, 3, 4, have A1, A2, A3, A4. This is apparently so the judge can search for page A37 easier than 37. I don't know why they'd be searching for a number rather than typing 37 at the top of the page, but Mr. Justice Man is more important than me. I'm just telling you what he said. Sixthly, when scanning documents, try to keep the resolution between 200 and 300 dots per inch. Now, this isn't as sharp as it can be, but it means that scrolling and loading is much, much quicker on the clunky Ministry of Justice computers. Seventh, bookmark the important documents. And the guidance is that you should describe the title in a neutral way and give the page number. So don't say the claimant's pack of lies, say claim form, page 5, for example. 8, as always, prepare an index, but if possible, add hyperlinks to the relevant parts of the PDF. Again, this is very easy to do in Adobe Pro. It's a simple right-click function. 9th, make sure you title your document appropriately. Don't just call the PDF bundle, because that obviously means nothing to anybody. Call it Smith & Jones bundle. I'm sure you would have all done this, but it's in the guidance, so I'm telling you what it says. 10th, this is an important one. If you need to provide last-minute new documents, provide it in 2 forms. Firstly, create a new fully completed bundle with the documents in. And secondly, have them as a separate set of individual documents. So for example, just the 5 new pages together. That means if the judges started looking at the original bundle, they'll take the small pot to add to them. Or if they haven't, they'll take the new completed bundle. It gives them the choice. Finally, remember, when it comes to filing, justice.gov email addresses can only accept up to 36 megabytes at once. So if your bundle is more than that, don't bother trying to email it. It just won't get through. And you finally made it, the virtual trial. Now, a lot of the guidance here relates to advocates' conduct, but I'm going to emphasize 9 points that, in my view, are important for everybody to be aware of. Firstly, to preserve bandwidth, only those speaking and the judge should have their camera on. And even if bandwidth issues persist, everyone can just turn their cameras off and effectively operate as a telephone hearing, as long as you're not giving witness evidence. Secondly, you should receive a Skype for Business link or something similar by about noon the day before the hearing. When you accept that invite, please note the email is automatically put into your deleted items, which is very unhelpful because the email contains the link you need. So go straight into your deleted items and move it back into the relevant folder in your inbox. Also, if you can, make sure you practice beforehand. Often for bigger hearings, the judge's clerk will allow you to practice the day before. And this is particularly important if you've got a Mac, because there have been quite a few issues with microphones not working on Skype for Business with Mac computers. I actually had one hearing a couple of weeks ago where my opponent couldn't speak and had to mime that she was agreeing with me, which fortunately she was, but it's obviously not ideal. Thirdly, if you've got a substantial hearing coming up, consider whether you could run the hearing yourself. Pay an external contractor to run their own sophisticated software and manage everything, particularly if you've got things like transcripts or data rooms to consider. But do remember, in this context, it's at least the Bar Council's view that you would then become the data controller for the GDPR processes. Fourthly, don't overlook the guidance that already exists in Annex 3 to Practice Direction 32, which I'm sure we'll all agree is one of our favourite annexes to that practice direction. It gives useful guidance on things like taking oaths abroad and the general aims of video examination. But please note this was written before the coronavirus pandemic, so you will need to bend it a bit because you can't have a person coming into the house to sort of sit next to them, as the annex suggests. Fifthly, several judges have suggested that they prefer having longer skeleton arguments for hearings now because they can't get as much out of Skype hearings. So consider basically writing written submissions if something's particularly important or difficult. Similarly, judges have said that you should probably try and prepare longer cross-examination notes for the advocates among you. This is because if the internet cuts out, or there's lag, or the witness doesn't hear you for whatever reason, or the Zoom doesn't quite connect, you'll need to be able to go back 1 or 2 questions or jump ahead 1 or 2 questions, and that's quite difficult if you're just doing it off the cuff. Seventhly, take your time with witnesses. Over a year ago, in the Invista Textiles case, Mr. Justice Burrs allowed oral examination via video link, and he said lag was a real problem. On top of that, he said that the witnesses were much slower than the lawyers at finding documents. So they were often answering questions about a document they hadn't yet found, and he found it very unsatisfactory. This is what Nick was saying: everything takes longer. Eighth, naturally, judges are concerned that litigants in person should not be unfairly prejudiced by remote hearings. Unfortunately, litigants in person are trying to use this to their advantage. In the last couple of weeks, I've had litigants in person claim they haven't received the bundle, can't open it, leave the call when things go badly and claim it was an internet issue. And it's quite difficult to deal with, but the best way to ensure the judge is on your side is to be as open and upfront with the litigant in person as you can. Send everything in advance: bundles, authorities, skeleton arguments, draft orders. Tell them any procedural points you're going to make, for example, adding new evidence. So the judge can honestly say, look, you've had your chance, I'm going to make the order anyway. Finally, remember that you will not be in the same room as your client or your counsel in most cases. So you'll need to have some method of communication. It could be WhatsApp, could be Microsoft Teams, could be email, but please be careful here. Remember, these are still court proceedings, and it is a crime to record or transmit them without authorization. So please don't go uploading to LinkedIn any selfies of you in action on Skype for Business. You could get in big trouble. This is our final topic. We're getting there. You've had your trial, and there's now two things we need to consider. The first one is, what happens if after the trial finishes, but before you get a judgment, there's some development? Society and law is changing so quickly at the moment, it's quite plausible that there'll be a new law or new decision or new development between trial and judgment. Can you bring this up? The short answer is yes, as long as you do it quickly. Now, there's two different situations you need to consider here. The first one is when the trial is finished, judgment has been reserved, but you've heard nothing from the judge. In that situation, you need to rely on the guidance given by Mr. Justice Macklam in Foster. So write to the court, write to the other side as quickly as possible and address these issues. In a nutshell, it explains why the evidence wasn't there originally, why it's important, and the impact it would have on either side if it was or wasn't allowed. On the other hand, if you've already received a draft judgment, but that's not yet been confirmed, you need to rely on the guidance in the Supreme Court case of Re LB. In a nutshell, the overriding objective is the key criterion, but there are other special factors. Things like whether the court would make a plain mistake, or the parties fail to draw something to the court's attention, or new facts are discovered. Looking at both of these tests, which are fairly similar, in my view, you're likely to have at least a reasonable argument to submit further evidence if, for example, your client simply couldn't access hard copy documents because of the lockdown, or, for example, the person who had access to the soft copy documents was ill with the virus or caring for someone or self-isolating. But as always, cases will be decided on a case-by-case basis. So make sure if this happens to you, you get as much detail as you can and act as quickly as you can. And finally, we come to enforcement of judgments now. The starting point is that there is no legal general restriction on enforcement of judgments, although in practice, judges will be very sympathetic to a lot of debtors in many cases, so do be aware of that. That said, there are 5 specific legal caveats to the traditional legal position. Probably the most well-known is Practice Direction 51Z. In a nutshell, as amended, that stays all possession claims until the 25th of June 2020. Now, a couple of weeks ago, some barristers tried a very ambitious argument to argue that Practice Direction 51Z was unlawful and invalid. Unsurprisingly, the Court of Appeal politely disagreed. That was the Arkin and Marshall case. But the court also gave guidance as to when the stay would not apply. And they said effectively it's only in cases where it would be a danger to the public health not to make a possession order that you could lift the stay. And yesterday, the Court of Appeal handed down its decision in Okoro and Hackney, confirming that this does apply to appeals as well, and potentially all other types of possession orders, even those outside of Part 55. In a nutshell, we're stuck with the stay in pretty much all cases. Secondly, there's a restriction on enforcement agents. At present, they're not allowed to come onto residential premises and take goods, or take goods from highways, for as long as the restrictions are in place on our households. This is told to us in the Taking Control of Goods and Certification of Enforcement Agents Amendment Coronavirus Regulations 2020. I had to practice that. Last week, thirdly, the Corporate Insolvency and Governance Bill was released. Now, this is a long and comprehensive bill, and our Chambers is giving 2 specialist webinars on it in the next couple of weeks, so please do sign up to those. But for today's purposes, I want to draw your attention to Schedule 12. This delivers on the government's promise to make it harder to obtain a winding up order in the coronavirus pandemic. As drafted, in essence, you cannot get a winding up order unless you can prove one of 2 things. Either that your client has reasonable grounds for believing that coronavirus did not affect the finances of the debtor, or that the debtor would have been unable to pay regardless of the coronavirus crisis. Now, in my view, unless you're trying to petition somebody like Tesco or Zoom, it's pretty much going to be impossible to say that they haven't been affected by coronavirus. Everybody has been, obviously. That's why you're listening to this via webcam. So really then a lot of weight, in my view, is going to be on part B, that the company would have never been able to pay. And that's going to be quite difficult to prove as well. So the government really has done its best here to make it hard to get winding up orders. The 4th limit is more general. Now, each country is obviously taking its own measures in response to the coronavirus pandemic. If you want to enforce a judgment in the EU, you'll need to check the country-specific rules. Now, I can't advise you on 27 member states' rules, but there is a helpful link in the slides to the Europa website, which provides a table summarising the main changes in each country, and that's at least a starting point for you to then take specialist advice. The final point, though, is, in my view, you should always ask your client, is it really worth enforcing a judgment right now? So many individuals and businesses are having real financial difficulty. It may just not be worth spending time, money, and effort trying to go through the process of enforcing a judgment if there's just no money at the end of it right now. And with that cheery thought, that is the formal part of our presentation. We will now turn to the questions. So as I said at the start, you can ask any in 2 ways. You can click on the Q&A button at the bottom of your screen and type something out, or you can raise your hand and we can then activate your microphone and let you speak. But don't worry, that will not activate your video. Thank you very much. To what extent do you think electronic bundles and virtual hearings will remain after coronavirus and lockdown? So in my view, there's sort of 2 answers to this. Certainly after lockdown, because I think the likely outcome, although I'm just speculating here, is that formal lockdown will end, but we'll still have some form of social distancing and limits on interaction for several more months. In that situation, I think we'll continue to do virtual hearings in a lot of cases and use electronic bundles. I do think, though, that there's a possible hybrid here. I've seen mooted in at least one court the possibility of doing part of a hearing in person and part of it remotely. For example, if you have a day that's just going to be the cross-examination of one witness, you could have the judge, the witness, and the cross-examining barrister all in courts, appropriately separated, and then everybody else watching via video link. So that's a potential way. But more generally, I do think there will be fundamental changes here because although it's not ideal, remote hearings really do help in a lot of smaller cases because it saves all the parties travelling. And certainly for simple cases, in my view, it's certainly as good as in person in a lot of cases.
Just to add to that, I think it also will vary depending on the court in question. So Chief Insolvency Judge Briggs was involved in an insolvency seminar given by our chambers a few weeks ago, and he was, I think, very keen on remote hearings continuing because they've worked really, really well in the insolvencies and companies court, and that's been my experience as well. I think, as you may have gathered from what I said, I think the county courts will be more reluctant to continue having virtual hearings unless and until the technology and the facilities are put in place to facilitate them a bit better. Because in my view, the county court really should be doing a lot more of its work by telephone, particularly very, very short applications, but it just hasn't done so, I assume, because of the complexity that this involves and the burden that it adds to the administration.
In a nutshell, Zach had difficulty trying to get a case listed in a certain court, so he had to go to the leading judge because otherwise the case wasn't going to be listed. And he says, have you come across this recently? How would you advise to proceed where the court have said they aren't listing new hearings? Now, in my view, one potential paragraph you can look here to is paragraph 2 of practice direction 2C, which says, in the county court, a claim or application may be started in any county court hearing centre unless any rule, practice, direction or enactment provides otherwise. And I've seen specific guidance from at least the County Court Money Claims Centre, which says that even if something is wrongly started there, that doesn't void the claim itself. It will just be transferred automatically to a different hearing centre. So one possibility, if you literally cannot get a hearing in the court you want, is to try to find the next best hearing centre. So to try and persuade a judge that you're acting fairly, maybe find the next nearest one to the defendant, if that's how it's been done, or consider what Nick was saying, is there a possibility of transferring to the High Court, and try and do something that way. Because then even if the court that you try as second best says, no, we're not the right one, you might be able to use the internal channels and internal posts to get your case transferred to the right court and listed that way. That would be my suggestion. Do you think this pandemic is pushing courts to upgrade their way of working and facilities? In some respects, yes. So I've heard at the start of the lockdown, the Ministry of Justice send out lots of new laptops to court staff and judges to use at home, because they, in many cases, aren't allowed to use their own laptops. It needs to be encrypted and have access to the certain systems. So that's probably a bonus. But unfortunately, as we all are very well aware, the government is spending an awful lot of money supporting an awful lot of people and businesses and public institutions at the moment. And I think the practical reality is, after COVID, there's not going to be much desire on the government's behalf to spend hundreds of millions of pounds fundamentally upgrading court systems. We've seen over the last several years basically a consistent cutting back policy really for court funding. So in my view, it might be difficult to hope for substantial improvements, but there may be more specific ones, things like wider use of Skype or laptops available to judges.
Just to add to that, which I agree with, I think courts would love to upgrade their way of working facilities, but they don't have the money. So I think if courts are going to be pushed to upgrade their way of working and their facilities, the government's going to have to fund it. It may be that the government will choose to do that if a business case is made that actually switching hearings from being in person to remote will save money in the long term. If that business case can be made, then the government may well support the switch. But my understanding is that there's been an ongoing review for many, many years, I think by Lord Briggs, to try and push a more technology-based way of working forward. But I haven't seen that impact on my day-to-day practice in any way. So I agree with what Matt said. There needs to be, I think, impetus from the government, and query whether the government's priority will be to launch a raft of spending measures on the courts, given how much money is being spent dealing with the pandemic.
That seems to be all the questions we've got for now. If ever there's anything you'd like to follow up on, our email addresses are on our website, and they're probably in the slides as well, which you'll receive shortly. We hope you've enjoyed it. Thank you very much for participating, and hopefully we'll see you again at the next junior programme or our insolvency webinar in a few days' time. Thank you.